day. So we have a lot to cover today, so I'm going to start with brief introductions. We have Chief Judge Glenn Kelley of the 15th Judicial Circuit, Scott Hawkins, a past president of the Florida Bar and a member of the Workgroup on Improved Resolution of Civil Cases, and our Board of Governors representatives for the 15th Judicial Circuit. We have Michael Gelfand and Robin Bresky. This is going to be interactive, so we're all on the screen together. We are asking that you mute your line unless you are speaking.
Okay, I have no audio.
We are asking that you mute your line. And if there is a time later in this town hall where we ask questions, then you will unmute and you will be able to ask your question. So we're going to begin. Lynn has sent around the report. And again, this is the final report of the work group on improved resolution of civil cases.
Just change, I can hook the speakers up when you change the computer.
No, he hooked them up because we tested
Please
it.
make sure you're muting your line. If you are not one of our panelists, please make sure you mute your line. Okay, so if you do not have a copy of that report, please feel free to email me or Lynn and we will make sure that you have one. So we're going to start this town hall with Scott Hawkins. And Scott, we'd like to know a little bit about how this work group was formed and what it was tasked with.
Thank you, Julia, for putting this together and for making this part of your administration. It's an honor to be on this panel with Chief Judge Kelley and Governors Bresky and Gelfand and yourself. So in terms of how the work group was formed, I'm not able to be very specific because I was not involved in the efforts to form the work group. What I can tell you is that the work group is a product of an entity called the Judicial Management Council. And frankly, I was not aware of the Judicial Management Council until I received a call in the fall of 2019 from Chief Justice candidate. And the question posed was whether I would be willing to serve on a work group being put together by the Judicial Management Council, assigned with the task of studying ways to improve the resolution of civil cases. And what led Justice candidate to initiate that effort, I'm not privy to that. But the first time that I learned of it was in November, I believe November of 2019. And when I talked to Justice candidate, what was clear to me is he was interested in the fact that I had spent time litigating a number of matters in federal court where the federal system had taken steps to try to streamline or make the system more efficient. He was interested in the fact I was board certified. And I think, and then we knew each other from my prior involvement with the Florida Bar. I don't know what efforts went into that. I know the Judicial Management Council is frankly the apex body that addresses issues associated with the entire court system. And that I understand on the Judicial Management Council, Chief Justice candidate is the chairman of the council, and Justice Wyda is an active member. That I do know.
Okay. And what were you all tasked with?
We were tasked to take a comprehensive look as a work group. The work group has 10 members, 6 of whom are judges. We were tasked to take a long look at ways to possibly improve efficiency within the civil justice system. The assumption going in was that there may be opportunities to make the civil resolution of cases more, with regard to the court's involvement, more efficient, and that the system was taking too long to reach resolution in many instances. And that was sort of the predicate point that was made at the outset when we first convened. I think we convened in January of 2020. So literally 3 months before the pandemic shutdown, we had a meeting. And then from that point on, all further meetings occurred via Zoom. And this was an extremely active body. I don't think I've worked harder on a bar function than anything compared to this. It was very active.
Okay, we're gonna switch over to Judge Kelley now. Judge Kelley, how were the chief judges included and what input were you able to provide?
Well, the chief judges were given notice of the draft report. I'm going to say probably now we all knew that it was in the works. We had gotten the word that the work group was meeting and that changes were coming and proposals were going to be made. We've known that for a while. We got the draft report late summer. I'm going to say probably in August or early September. We were given a copy of the report, and the Supreme Court did solicit our thoughts on the report, and we were able to do that. We did it in a couple of different ways. Initially, there was a survey that was kind of sent around that kind of went rule change by rule change, where comments could be submitted. But then more collectively, what was done is that the chief judges had several conferences where we essentially drafted an overall response in the form of a letter. Now, that letter does not get into the specifics of every rule change. It talks more broadly about concepts. And so, we had several discussions about what we should express to the Supreme Court. We were given that opportunity. Chief Judge Sorstrom out of the Second Circuit was the one that put that letter together on our behalf, which attempted to basically reach a consensus among the chief judges. And reaching consensus among chief judges is the same as trying to reach consensus among judges. Sometimes it's just not possible, but there was pretty broad consensus on most of the concepts that were contained within the draft report. And just broadly speaking, I don't think I can go specifically through the letter with you, but broadly speaking, the chief judges felt that conceptually that the draft report was a move in the right direction in terms of bringing greater efficiency to the civil system and to leading to quicker resolution of cases. There were some broad-based concerns expressed concerning loss of discretion at the trial court level in some of the rules. And there was an expression that some of the rule changes were a little bit more complex than they needed to be. In other words, they could be a little more simply expressed. They were very, very specific, and that led to some complexity. There was some concern expressed as to whether county civil should really be included within the case management proposals that were being made, the differentiated case management. But we were given a full opportunity to put together whatever thoughts we had on the subject and to express those to Chief Justice Kennedy, and we did.
Okay, Robin Bresky, where are we now in terms of the report being presented to the Board of Governors?
Sorry about that. The report was presented to the Board of Governors December 3rd at our Board of Governors meeting. And it was a fairly lengthy presentation. And we all were really educated, I believe most of us for the first time at that point. That's where we stand now. And my understanding it is now with the court, and we are waiting for them to move forward on it before they would then open up a comment period of time, which can be done directly with the court when they do that.
Okay. Scott, can you talk to us a little bit about the actual product of the report and some of the recommendations that are being made?
I can. To be fair, I can't precisely go through every dimension in much detail. I mean, this is a huge effort. The work was divided into pods, and for example, a number of the judges were assigned to look at the whole issue of case management. So that would be one example. Another pod was created to look at issues regarding discovery and motion practice. I was in that grouping. But in our initial meetings, we talked about various tools that were available or could be available under the rules for enhancing efficiency and giving, frankly, circuit court judges greater capacities to encourage timeliness, efficiency, and how to make the process, frankly, more cost effective for clients. And an overarching point was case management. In the federal system, and I realize the federal dynamic is considerably different than the state when you've got federal district judges appointed for life, and that the pressure of getting reelected is not there. I appreciate that's a much different paradigm. But in the federal system, your federal district court judges are fairly active in moving cases along, assigning cases to tracks, and frankly, ensuring that cases stay on schedule. Yeah, in my experience, you know, some will say that in the federal system, it's the judges that drive the cases, whereas in the state system, it's the lawyers that drive the cases. I'm not sure that's a fair dichotomy, but that was bandied about as sort of a difference in orientation. The sense was, though, that we could look at helping judges develop tools for promoting case management. So trying to keep cases on a set a schedule based on the complexity of the case. So we created 3 tracks. That will be similar to what you see in the federal system. But a big thing is ensuring that the case, once assigned to a track and assigned to a schedule, stays on that schedule and doesn't deviate from the schedule, absent, and frankly, an extraordinary circumstance. So 2 things in particular jump out when you think about this: is the ability to get a continuance is declined radically under the work group plan. And second of all, when a case, the matter of a case being at issue is no longer the controlling feature for when a case is set for trial. So early on, if a case is set for trial in May of 2023, you're not necessarily going to get that trial date bumped by amending your pleadings that prior March. Now, that would be an example of something rather dramatic that was basically discussed as a tool for trying to keep cases on track. The sense being that when cases get to trial, they get resolved. And until you put the pressure on the litigants to get to the trial, the matter of a case lingering is enhanced. So that was a central feature behind a lot of the discussions. The ins and outs of case management, that was driven by the pod created by all the judges. Chief Judge Morris set that up. And I think they did a terrific job. They looked at rules from states across the nation where this has been addressed, as well as different federal rules. So I hope I answered your question.
Thank you, Scott. Judge Kelley, what do you hope our attorneys will take from this report?
Well, a couple of things. Number one, there is, I think, a belief, and I think it is probably a well-founded belief from the Supreme Court on down, because it comes through the task force, that our system is not as efficient as it needs to be, and that litigation is taking much longer and costing much more than it really should, and that rather dramatic changes are needed to basically make the system more efficient. And these are, I don't think anyone can look at these changes and not describe them as fairly dramatic. They are dramatic changes. And so what I think attorneys need to understand is that there is the belief coming from the top down, shared by many, that we're not as efficient as we need to be, and that attorneys are going to have to re-examine the way they litigate cases in state court. And of course, major significant point here is this is not just one circuit. This is the way the state of Florida is going to operate going forward. And so I've sort of been speaking about this since I first heard about it. You know, when I first spoke with Judge Morris back before I was chief, when I was administrative judge in civil, I don't want to say that I don't want to say I've been sounding the alarm, but what I've been trying to do is I've been trying to tell everyone, please pay attention to what is coming, because there is a change coming, and it's a dramatic change. And the time to start thinking about it and thinking about how you're going to approach litigating cases in the state of Florida in state court needs to start changing now. And so that's the big takeaway. The change is coming. That there's a view that this changes needed. I don't know what the final product is going to look like after the Supreme Court obviously has public comment. They have solicited views from a lot of different groups and people. But I think it's in the end, and I don't have any inside information on this, so please don't quote me on this, but I have a feeling in the end, the draft report that's been submitted, the final rules that are going to be adopted are going to look a lot like it. And so these changes are coming, and lawyers need to pay attention to.
Okay. You heard Scott talk about the emphasis on differentiated case management. And I know you have talked to us in our prior town hall about this. Can you share what the 15th has done with their DCM systems and what you think is working, what isn't working, what you'd like to see more of, less of?
Sure. And just historically, I know I've spoken about this before, so I don't know whether this may be redundant with respect to some folks that are now listening, but just going back historically, when this was, when the Supreme Court mandated differentiated case management last year, obviously it was a surprise. We didn't know that it was coming. It came through an AO that was, basically related to COVID. It was in one of the emergency AOs. So what the circuit did at that time is immediately developed two different AOs to deal with differentiated case management in two different circumstances. One had to do with cases that what we call the retroactive cases. They were cases that were already pending as of April 30 last year. We had to formulate a plan to get basically a case management order in every one of those cases. And then we also formulated an AO for cases prospectively going forward from April 30 last year forward. And what we basically did is we established a differentiated case management plan and two different AOs to deal with that. And then we went about the task of trying to implement that. Now that was a very big challenge last year because with respect to the retroactive cases, we started with a universe of over 36,000 cases pending in both circuit and county civil. We were able to narrow that down because some cases are exempt. Cases that were set for trial already had their own time limits set for us. We got that down to 18,000, but we still had to go through with case managers and make sure that we had basically a case management order and plan in place for every one of those cases filed before April 30 of last year. It was a monumental task. We have accomplished it. We've gone from a position where I just got the latest report last week, where we only have about 94 cases out of the 18,000 that don't have a case management plan in place. And some of those probably already have a trial order or some other reason why they don't have a case management plan in place. So we've gone through that task of making sure that there's a case management plan in every one of those retroactive cases. Case managers are now turning their attention to the new filed cases because those are now coming online where they're going to be required to have a case management order in them. So we're basically changing our focus from becoming compliant with the retroactive cases to moving forward. And so we are implementing the plan that was put in place in April. In addition to that, what I am now starting the process of doing, in fact, I've got a meeting tomorrow. I've asked select civil judges to sit down with me tomorrow and begin the process of now reviewing our administrative orders on differentiated case management to find out if we need to tweak those orders. In other words, things that we need to do. What have we learned? Do we need to improve what we're doing? Do we need to become more uniform in certain places? And part of that task, quite frankly, is to look at what we believe will be coming when this draft report is adopted in an amendment to the Civil Rules of Procedure. So in other words, looking forward, what should differentiated case management look like, if any different than what we have now? One of the things that we've relied on very heavily, and I'm not sure that it's worked as well as we would like it to, is we've relied on attorneys to get together, agree, and present themselves an agreed case management order and plan. That probably has not worked out as well as we would have liked. We spend a lot of time on what we call non-compliant cases. Those are cases in which the attorneys were required to basically agree to a plan, agree to a case management order, and submit it to us, and then we've not received it. And our case managers will go through and identify what cases have not yet complied. And then the individual civil judges have to take action, either by entering their own case management order without input from the attorneys, or by basically scheduling a case management conference to discuss it with them. So that has not worked quite as well as we would like. Otherwise, the plans are being implemented, they're being put in place. We're looking ahead to, what this is all going to look like when we have those additional tools and requirements that are set forth in these proposed rule changes.
Thank you, Judge Kelley. Scott, we also see in the report an emphasis on continuing legal education. Can you tell us what the report says about CLEs?
Yeah, so that's a general reference recognizing the great need that will come from adoption of the report or some version of the final report. Again, we don't know what the final scope of adoption will be. I think Judge Kelley probably is pretty accurate. It will probably be adopted significantly upon receipt of significant comment from all the different sections that will have a chance to comment. The concern about CLE is this: we need to make sure that all different dimensions of the bar and those who provide CLE instruction promote an understanding of the changes in the rules. Now, we haven't said this has got to be required, but I'm frankly envisioning that the bar will have courses. I suspect all the certification committees will probably have a unit on the new rules and the way the new rules work. I would not be surprised if the Young Lawyers Division has a course on how the new rules vary from the old rules and how they're being implemented. I would expect a lot of that to occur. I'm sure the trial bar and including the plaintiff's bar, they're going to develop course materials that speak to that. That's what is generally meant. That type of broad scope of treatment and education is what is generally contemplated here. I would not be surprised if there are courses that are developed by the Florida Bar so that people readily understand or have an opportunity to study the changes and how they're going to be implemented. But in terms of particular course material, that's not specified in the draft report or in the final report.
And Scott, staying with you, also in the report, they talk a lot about ADR. And can you tell us what the committee considered and what they're recommending in regards to ADR?
Well, ADR was recognized by the work group as extremely important and frankly, quite successful. The success rate attached to mediations leading to conclusions is extremely high. So the ADR is like what you're accustomed to. It's mediation, it's non-binding arbitration, it's non-binding trials. It's the types of ADR that is presently available. And it's going to be very much encouraged, and it's going to be mandatory before matters go to trial. But there was no new ADR program created or no new ADR approach that was advocated by the report. Just a general recognition of how important it is.
Okay, we're going to open it up to all of our members. If you have a question, you can unmute yourself. Please try to raise your hand first so we can try to do this in an organized way. Anyone with a question? Okay, I'll let you guys get up the courage to ask a question, and I have some more questions. So, Judge Kelley, the report mentions the addition of 2.250B, which would require the chief judge of each circuit to serve on the chief justice and the state court's administrator an annual report that lists all of our active cases that have been pending for 3 years or more at the end of the fiscal year. Is our circuit already doing something like this?
No, I'm not aware of any circuit actually filing such a report. The raw information in terms of cases and closure rates and all of that really can be obtained from the clerk's office from filings that the Supreme Court already has available to it. I mean, they could compile that information themselves. I don't know that they do at this point, but there's been no there's been no requirement for such a reporting in the past, and there's no current report that is submitted to the Supreme Court relating to cases pending over 3 years or for any particular length of time for that matter.
And this question is for Scott. When the report mentions suggested amendments to the oath, including making the delay provision something that's more all-encompassing, what did the committee consider? What did the work group consider when they looked at the oath? And why did they think that was important?
So I can't quote the oath verbatim, but there is a section toward the end of the oath that talks about, in general terms, that a lawyer who's sworn to adhere to the oath by the Florida Bar agrees to not engage in dilatory conduct and not to pursue a cause for out of malice or for filthy lucre. I think that's the terminology used. It's a little archaic, but the point being that we all, when we become licensed, we agree not to delay cases for monetary reasons or for advantage reasons, to advantage the client. And the sense on the workroom was that there's a bit of an incongruity between the way some lawyers operate, and I think the sense is it's a fairly modest minority of lawyers who the word sometimes used is purposely churn or create needless activity or non-productive activity for reasons of wanting to generate income or for perhaps reasons related to gaining case advantage or frankly wearing the other side out. There's a sense that that type of conduct is inconsistent with the oath. And I actually did some work on this at the request of the work group, but there wasn't a sense, to be clear, there was not a sense that the oath needs to be modified. It's just that the circuit judges need to be given more tools to try to discourage, if you will, that type of dilatory conduct. And there's a new sanctions rule that is designed, frankly, to give judges greater power to require, through the imposition of sanctions, more compliant behavior.
And I think Michael Gelfand had some comments here as well.
As we listen to the comments and the summaries, I think it's important that we hear what I believe the justices are telling us. And, you know, looking at the names on the screen, we're almost preaching to the choir, folks that comply. What they're looking at is not only the complaint of many business people and citizens of too long and too expensive, but also they're looking at the growth of ADR as being almost in competition and thus undermining the role of the courts and the system of ensuring neutral decision makers that are respected by all. A large part of this has been somewhat touched on is having the courts more interactive, and on the part of continuing education, it's interesting that there's a requirement now, almost as there is for death penalty cases now, for judges to have continuing education. And there's this process that they have now, the pretrial coordination court, particularly where there's continuing education that's being required by the rule if it's been adopted. Part of this also is we're looking at the rules taking, as a comment of the oath, more aspirational statements. You may find of interest the new proposed rule 1.279, and for those that have this, I believe this is on page 152 of the report, where it takes what we've seen in a number of the court decisions, the anti-gotcha statements by the court, and now they're trying to put that and encapsulate that into court rules. And as we move forward, part of picking up from Judge Kelly's comment of needing to adapt now, you'll notice that in motion practice, if you don't set it, in essence, you abandon the motion. And there are many prospects now where the court may now rule without a hearing and may dispose of cases without a hearing. So, for example, many of the motions to dismiss that are filed that are not set for hearing If you don't move forward on those, the case goes by the wayside, which also moves the cases forward. You'll also see in terms of discovery, continued obligation to update and supplement discovery, somewhat similar to the federal system, which then relates back to the sanctions. And I don't know if you want to get into that, if it's a little early in our conversation.
I think that's fine. I think we can talk about that.
Take a look at the new rule and at what it's there for. And I don't know if Judge Kelley wants to chime in at this point, but it appears that many of the courts have felt that they've been very constrained by the District Court of Appeals decisions on sanctions. And this expands it. It's notable that the rule expressly, or the proposed rule expressly, states that there doesn't have to be a willful determination of, or a factual determination of willfulness. The court seems to be encouraging sanctions by providing a ladder or a stepped process for sanctions. So those are there in essence to help assure that the cases move along and that those attorneys that are not complying have, shall we say, an extra incentive. One of the problems that Chief Justice Morris, when presenting the work group report, noted that in a state with elected judges, that may be a difficult road to take, or a difficult method of implementing sanctions. We'll have to see how that rolls out.
Judge Kelley, do you want to say anything on this?
Well, I guess what I would say is this, and it kind of dovetails with that comment, and also with what Scott had raised earlier. I mean, if you look at these rules and the proposed changes, they do grant in very broad stroke and in very specifics in other areas, much more authority and latitude towards trial courts to move cases along and to, basically eliminate many of the abuses that we do see in civil litigation, and to keep cases on track. One of the things I have heard Chief Judge Morris talk about this, because he's an appellate judge. One of the things that he commented on very early on was that the appellate courts need to start supporting the trial courts when they try to, basically make sure that attorneys are, acting appropriately, not acting for purposes of delay, and moving cases forward. And there was a feeling, and really has been a feeling, that many times you really can't do too much under the current rule structure, current appellate cases. And these rules that are being proposed change all that very, very dramatically, and not just in the area of sanctions. That's one area, and it does open up the availability of sanctions that are not there now, but just in in denying continuances, in motions that we can all cite and have all seen, that have sat on the civil bench, the various ways that cases get slowed. Motions to dismiss, filed, never heard, case not at issue, can't set it for trial. Amendments, sometimes last minute, and case law and amendments, basically dictates that if it's not futile or done in bad faith, you're supposed to allow it, and then it takes the case off the trial calendar. There are all these things that are in these new rules that do give the trial judges tools in order to really move cases forward in a timely fashion. And that is the theme of the entire draft report from my perspective. It's making sure that cases move efficiently, making sure there's not game playing done in the litigation context, and the judges have the ability to make sure that cases move through the system efficiently, and to sanction attorneys that do not comply with the rules and that intentionally delay things. So there's a lot in here that trial court judges can use, and if adopted, will use. And the sanctions is just part of it. It's the whole rule change, the whole proposed draft report, the whole use of differentiated case management, setting deadlines, making those deadlines stick. The whole idea is to provide the trial courts with the ability to move cases forward in an efficient way. Some may argue, too quickly. I mean, you can have that argument, you can have that discussion in good faith as to, reasonable people can disagree. But nevertheless, it is to start pushing cases through the system in an efficient way and to make sure that cases are resolved in a very timely fashion and that they don't linger forever.
And speaking of timelines, Scott, can you walk us through the tracks and some of the general timelines associated with each?
I can generally. I'm flipping to my report pages. So you have three basic tracks that are contemplated under this broad rubric of differentiated case management. And so this would parallel the federal system in the Southern District pretty similarly. You have a streamlined track, you have a complex track, and in the middle you have a general track. The report talks about timeframes in terms of getting from filing to conclusion on trial as to each track, so the preferred timeframe. I'm not able to tell you exactly what the timeframes are. I got to find that section.
I think it's 12 months, 18 months, and 24 months.
You're right. That's right, Judge. That's right. So you're right. So the streamlined case would be one that you could get from filing to conclusion within 12 months. 24 months would be your complex case. So what would be a reasonable streamlined case? So if you've got a breach of contract under an equipment lease, for example, that might be an example, or a simple replevin case. Those might be examples of something that could be streamlined, where you've got the amount in controversy over 30,000. The complex track could take on a variety of things. I do a lot of at Jones Foster, a lot of work related to trade secrets, and I deal with cases involving a lot of complex discovery issues and ESI issues. Those features would possibly lead to a case being placed on the 24-month complex track rule. And the complex track rule is buttressed in the report. The existing rule is strengthened, in my opinion. And then in the middle, you've got the general case, which, as Judge Kelley just said, the expected time frame is from filing to conclusion would be 18 months. Those time frames, frankly, will be faster if we're able to get those time frames in place. That will be much faster than the current situation. Now, I realize there are many lawyers who are extremely diligent. I've had many lawyers call me about this. Some very prominent lawyers talk about how diligent they are. I don't think this report's going to have much bearing on the lawyer who's very diligent, who gets his case to trial or her case to trial as quick as possible. I don't think it's going to have a lot of bearing on that segment of the bar, whether it's plaintiffs or commercial. But I do think that the judges are going to be armed with additional tools to, frankly, mandate compliance or sanction bad behavior for those lawyers who are dilatory. And I realize it may be a modest segment of our population, but the work group felt that was a universal problem, frankly, in all courts, and significantly in Southeast Florida.
Robin Bresky, I know you have a comment.
Well, first of all, thank you again, Scott, so much for all your hard work on this. I know it's a huge undertaking, and to all the panelists on the call. I just wanted to say, when we did have the presentation on December 3rd at the Board of Governors, there were some concerns from people in attendance about this, and from some smaller firms and solo practitioners, and how is this going to be feasible to get this done when so many things may come up at the same time. And so there are concerns, and we as the Board of Governors, Michael, myself, Saya, and Ron, please reach out to us if there's things that you want to discuss. Fortunately, we have ongoing, conferences with the justices, and I think it's important to have the dialogue. I also wanted to talk about the time frame. My understanding, and when the report was made to us, that it would be this is all probably going to come to impact us about 18 months from when the Supreme Court moves it forward. That's the rough timeline is what I understand. And so we don't know when that will be, but it should be about 18 months from when they move forward on that. I just wanted to mention those few things. Thank you.
Dan Rosenbaum, I see you have a question. If you can unmute yourself.
For Judge Kelley. Judge Kelley, the federal system operates pretty efficiently because it's staffed by magistrate judges and many law clerks. We don't really have that in our circuit. And I was wondering what on the court side is going to be done, if anything, in order to allow the cases to move as quickly as the tracks allow them. And just as a side note, right now we're having some problems getting hearing time on a lot of the cases because of the case management issues themselves. So I don't know if the court contemplates adding clerks or additional staff to help these cases.
I guess the short answer is we're going to do the best we can because we do not have the ability really to hire more staff attorneys or case managers unless the legislature gives us the money to do it. And we're given those positions. So I will note one obvious major difference between the federal court system and the state court system, and I don't need to tell anyone on this call the difference is that the resources are significantly different. Obviously, each federal judge has 2 or 3 law clerks assigned just to them, and they have far fewer cases than we do. So it is going to be a challenge in order to, accomplish the tasks that this draft report wants accomplished. We're going to, structurally, we're going to take a look at where we put our resources. I think a lot of it, at least up front, just getting the differentiated case management in place has diverted a lot of our resources. But once we've gotten through that initial hump and we start moving forward, we're going to try to develop strategies that allow us to, to put the resources on what needs to, what task needs to receive the first priority. And sometimes that hearing, I might add the rules. I mean, if you look at the rules, there are significant requirements placed on the judges too. I mean, those rules, if adopted, talk about the reasonable period of time to get a hearing, depending on the length of that hearing, whether it's 15 minutes, 30 minutes, an hour, or longer. And there's some expectation that the judges will be able to provide hearing time within those timeframes. Now, I will say this, remember that we may not need the same number or types of hearings that we've been having in the past, because there's going to be the ability to decide motions without a hearing if the trial court deems that appropriate. And I can tell you that most of my colleagues probably will, in many cases, deem that appropriate. There are many motions to dismiss and other motions that, hearing time is scheduled and taken up that, really can be done on the papers. And so I think that we're going to have to look for internal efficiencies with respect to, opportunities the rules give us in order to, basically meet the workload we're going to have. And I do think, candidly, that it's going to reduce the number of cases, long term, which will obviously help us also be more efficient. But, we're not blind to the challenges that this is going to place on the judges in terms of making hearing time available and moving cases forward. Because one of the things that will occur naturally as a result of this is that because these timelines are to be strictly construed and applied, there will be a lot of motion practice that needs to occur early in a case. And so we're going to have to be ready for that in terms of getting discovery issues resolved quickly so that the case can stay on track and be tried within the timeframes that the Supreme Court expects. So if I wish we had more resources, we're frankly having difficulty even filling the positions we now have. And that's just the work environment that we find ourselves in terms of being able to offer competitive salaries. So it's going to be a challenge. We're going to look at it. That's one of the reasons I'm meeting with some of the civil judges to start looking forward to the day when these rules actually are adopted, because I do not want to wait until the eve of the adoption of these rules to figure out what we're going to do. We're going to start that planning process now. We're going to start talking with our civil judges. We're going to start figuring out, is there a better way to do things? And if so, what is that better way?
Thank you, Judge Kelley.
Judge Haffel.
Good afternoon, everyone. First, thanks to the bar and to the Chief Judge for being so proactive in holding this meeting, and to the Board of Governors and to the members of the committee. I know Mr. Hawkins, and I'm not sure if there's anyone else that's here, but Dan stole a little bit of my thunder, and that is actually somewhat bristling at the mention of comparing our situation to the federal court situation and the manner and method cases are handled on the federal system. As most of you know, each federal judge on the district level has 3 dedicated law clerks. It used to be 2 plus a JA, and they can opt now, as I understand it, to 3 full-time law clerks if they wish to dispense with their judicial assistant in a traditional sense. And of course, here in West Palm, we are very, very blessed with 2 exceptional magistrates. At least at this time, there may be a third, and I don't know if that's going to be an additional magistrate here or not, but they too have 2 full-time law clerks. We are working in a system where, as Judge Kelley, as the Chief said, we have approximately in each of our circuit civil divisions 1,600 active files per judge, with no dedicated law clerk. We have, and I don't want this to go unsaid. We have several very dedicated staff attorneys who work very, very hard. And by no means am I being critical of their performance. They are tremendous, hardworking, overly worked folks in many cases. But to try to implement the system that is trying to be implemented here, and Mr. Hawkins just coincidentally has heard me speak about this in open court, appealing to senior members of the bar to somehow please attempt at this critical juncture to get us additional support, because to expect this process to be implemented under the current conditions, I would, as the most experienced member of the Circuit Civil Division, respectfully suggest that it is going to be extremely difficult without having the support we need. And again, some may be saying, well, are we confusing support help, i.e. case managers, with staff attorneys? And I will say unequivocally no, because in order to be able to better handle our 1,600 open files, the necessity of dedicated clerk assistants, I think, speaks for itself, because the case management not only deals with the administrative issues, but also, as importantly or more so, deals with the substantive legal issues, of which we have really no dedicated assistance. Again, when asked, they are willing to help and they do a good job. But using just a few for the 50 some odd judges in the main courthouse, again, how this issue has never really been addressed in my 22-year career that I'm aware of is beyond me. And I'm wondering whether, Mr. Hawkins, that issue has been addressed by the committee. Thanks.
I wanted to unmute myself for being unmuted by whoever's activating that. First, Judge Haffel, I acknowledge you've brought this up to me privately and in open court in matters that we've had together. And I can tell you that when the work group first convened, it was a universal view that the state is probably underserved in terms of the number of available trial judges. And that it was recognized there's a huge difference in terms of workforce between a circuit judge in state court that may or may not have the help of a clerk, an interim or temporary or occasional clerk, versus a federal judge who has 2 or 3 clerks around the clock all the time. There's a huge difference, and we acknowledge that. Quite honestly, that was beyond the jurisdiction of the work group in terms of our being able to say we need more judges. I can tell you from what I understand that the Chief Justice has been persistent in requesting additional judgeships. I don't know what his current request is to the legislature, but I know historically that's been stated, and in part, it's a direct function of demographics. I mean, the state of Florida, many would say, is exploding from a demography standpoint in terms of its population. And that justifies more judges, in my opinion, to serve, frankly, our citizens. And that's at this kind of at the root of a lot of the concerns here, is that the citizen litigants, those contractors who are unable to get their matters resolved, those folks who think they've been ripped off by an insurance company or somebody else, those folks they're suffering because the state court system is not moving more quickly. And I do believe that's a significant driver in what led the Chief Justice to formulate that. But I'll be the first to recognize this is a very ambitious report. Structurally, there may be things here that are not achievable in the short term. There may be. There's going to be a lot of discomfort created if this is adopted in large measure as is presently set out. And that over time, I think that what will happen is you'll have fewer cases in the system, at least on a per capita basis, because the population will continue to grow. So I think the system over time will eventually become more effective, but I'm not suggesting that this resolves the problem you've identified with the judiciary not having enough capacity. I'm not suggesting this is a solution for that problem. I recognize that, and the work group acknowledged that.
Thank you.
Thank you. Michael Gelfand.
The issue of resources obviously is not new. What the work group report, though, may provide an impetus for is to realign the, shall I say, inequitable allocation of resources. And I would anticipate that, obviously not this year, but as the report and the rules are reviewed, there would be an economic impact statement, if you would, from the court as to the needs. And that would be something that then would be justification for the legislature to provide additional funding. A little bit premature at this point. I would say right now, the bar's focus, I would say, for funding is for trial court judge salaries. 2 years ago, Supreme Court, last year was the Court of Appeals. This year, it's dealing with trial court judges' salaries. And on an ancillary basis, dealing with the issue of funding for a new 6th District Court of Appeals and all that goes into it. But one of the things is, again, looking at the names on the screen in front of us, all of you are very involved and you know who your legislators are. And of course, not being partisan in any way whatsoever, I would say that as members of the court, you have an obligation, if you would reach out to those that you know on a personal basis and reinforce with them the need for the funding, current issues that are happening, and also looking out elsewhere because they are responsive to that as opposed to perhaps just getting a paper in their offices in Tallahassee. So let them know, many of you know that I've been very involved in that process, and that is very effective, and I urge you to do that.
Are there any other questions? If not, Judge Kelley, do you have any final comments?
Well, I guess I would just summarize what we've been discussing, and that is that, I do believe these rule changes in some form are going to occur. They are going to present challenges and opportunities, I suppose. There'll be challenges for the attorneys, and as we've identified just recently here, there'll be challenges for the judiciary. We do have limited resources, and we are going to have to do the best we can to implement these rule changes. But as I've been saying since I first learned that this was in the wind, which was last year, probably around March or April when I first heard about this, I'm just trying to continue to urge everyone to pay attention to what's occurring. If you have comments, obviously you need to make them when the public comment is opened up by the Supreme Court. Even if you do not have comments, you need to start looking at these rules, understanding how they're going to change the practice of law. I can just tell you from my perspective, we're going to start looking at these rules and what's already been mandated with respect to differentiated case management, and figure out how we, with our limited resources, can also deal, with the requirements that are set forth in these rules. Again, there are things in there that are significant with respect to the manner in which attorneys are expected to practice law, but there are also there are rule changes which materially affect the trial judges and put requirements on trial judges which have not previously been there. Now, you can argue about whether that's good or bad or the philosophy behind it, but that's the fact, that there are requirements that are set forth in there that are going to affect the trial court judges as the way they approach cases. You mentioned the reporting requirement. There is no such reporting requirement now, placing on the chief judge a requirement to report cases pending over 3 years. There is no requirement like that. I do not know of any report that's been submitted like that. Certainly, I've not submitted anything to the Supreme Court in the short time I've been sitting in this chair, but there are a lot of changes, both on the side of the attorneys and on the side of the bench, and we all have to pay attention to it and recognize this in some form. This is going to happen. I think that's inevitable, and so just pay attention, get your comments out there, and it does have an ancillary impact on other things, budgeting, things like that. I mean, think about all of those things in terms of focus, but the main thing to take away is it's going to happen. We can sit back and say that it shouldn't happen, but I think we're well past that. I think the work group has put in their effort. I think it was done because Justice Kennedy and the Supreme Court thinks it needs to be done, and so we need to operate under the realistic expectation that this is coming, and that we're going to have to adapt to it, and to learn how to function in a little bit different world that we've been functioning in. So that's my takeaway. Just start to get prepared. Don't panic, but start to get prepared, and think about the ways in which this can be implemented, going forward as efficiently as possible without creating, any level of chaos, either in the practice of law or with respect to the manner in which judges handle cases.
We thank all the panelists for being here with us today, and we thank all of our members for tuning in. We appreciate it. We're going to make this video available for free for all the other members who could not attend today on YouTube. Thank you. Have a great afternoon.
Thank you.
Thank you.
Thank you, Julia. Thank you, panelists.
Thank you.